SJC-12278, Roma 3 Limited v. Town of Rockport Board of Appeals.
Good morning, Ms. Cowan. Give us a moment. You may proceed.
Thank you. Good morning, Your Honor. Jackie Cowan for the Town of Rockport. By this appeal, we seek to overturn not just the decision of the land court in this case, which the court stated it was constrained to make, but the decision of the appeals court in the case of Hanlon v. Sheffield, that cities and towns, any local regulation of the use of land for the landing of private, non-commercial aircraft must be approved by the State Division of Aeronautics, which I will refer to as the division. The Hanlon holding was based on the appeals court's interpretation of Chapter 90, Section 39B, in particular the 5th paragraph, which provides that a city or town may make regulations relative to the use and operation of aircraft on an airport or restricted landing area located in the city or town, so long as that regulation is approved by the division. And also the court's determination that an exception in the 4th paragraph of the statute for land that is used for non-commercial private aircraft does not apply to that 5th paragraph requirement of division approval. I'd like to give just a very brief overview of Section 39 as a whole. The 1st, 3rd, and 4th paragraphs were enacted in 1946. Read together, they require that any restricted landing area or a municipal airport must receive approval by the Division of Aeronautics prior to being built or operated. However, it accepts from that requirement landing areas that are for private, non-commercial use.
Before you go too far,
Yes.
Restricted landing area versus non-commercial private use restricted landing area, what's the distinction?
So in Section 35, which is the definition section, and the division in Roma rely heavily on this definition, restricted landing area is an area used for the takeoff and landing of aircraft. It does not distinguish between commercial or non-commercial, and the definition further states it may be regulated by the division from time to time. And the division and Roma point to this definition as saying there is no distinction between commercial and non-commercial when it comes to the division's regulatory authority. However, that disregards a canon of statutory construction, which is that general statutory language must cede to more specific statutory language, and it disregards the fact that in the 4th paragraph of Section 39B, it specifically and explicitly states that non-commercial private restricted landing areas are exempt from division approval and therefore division regulation.
Well, but there's different levels of review in the 3rd paragraph, right? Or maybe it's the 2nd paragraph, I can't remember. The division does certain things to other landing areas, and then it has a lesser role with the non-commercial private landing areas, right?
So I disagree with the last part of what you said. It does not have a lesser role. It has really no role if we're talking about regulatory.
It has some role, right? Read the last sentence, doesn't it? It has some role, doesn't it?
It must be notified in writing of the fact that the area is going to be constructed. But in terms of regulating, it can't disapprove it and it can't condition it. And if it can't disapprove it and it can't condition it, then it has no regulatory authority.
So in your interpretation of this, I just want to make sure I understand it, because I was on the earlier panel, and you've done a much better job briefing this than we had in the appeals court. So you've raised some new issues, at least for me. But what are the town's powers now? I understand they can fully regulate, you say, the non-commercial private. Can they regulate Logan Airport, other airports? Do they have only power in this very limited area, or are towns who know nothing about airports in general more involved?
So that depends on how this court interprets the language of the 5th paragraph, and I would refer the court to the statement made by the division when it submitted the legislation that became paragraph 5 in 1985, and that's in the appendix at page 175. And it stated that at that time, in 1985, municipal authority, there was no municipal authority to regulate the use and operation of aircraft. And it referenced the Lockheed case, which had been decided 12 years earlier by the Supreme Court. Now, we know from cases decided in the wake of Lockheed, a line of federal cases which are cited in the last section of our brief, that the use and operation of aircraft is different from the regulation of the use of land for the takeoff and landing of aircraft. And this line of federal cases states that Lockheed held that the Federal Aviation Act preempts use and operation of aircraft. It does not preempt local or state regulation of the use of land for takeoff and landing of aircraft. So to the extent that the fifth paragraph, which states use and operation of aircraft, applies to that, the use and operation of aircraft, separate from regulation of the use of land, then I think Roma may be right in that it is a conferral of authority where none previously existed, and it's very limited in that it must be approved by the division, and of course can't conflict with federal law.
Well, the division is going to retain control through the fifth paragraph of all. I understand that, but you're suggesting that there's residual municipal authority to regulate flight in Massachusetts, and I'm just trying to
flight.
Well, if you have a landing area, you're involved in aviation. You know, you have planes. It's not like they just get to sit on the ground. They take off, right?
But
Isn't it whether it can be there at all?
say again?
Isn't that whether it can be there at all? It's not regulating the flight of them, it's whether they can even be there.
That's the point that I'm making, that the line of federal case law makes after Lockheed, that they are two different things. That flight, operation of aircraft, is different and separate from the use of land
So
to allow.
if you can't have the airport to begin with in a particular place, it's not going to be a question of regulating flights coming in and out of it.
Correct, that doesn't play into it, at least with respect to that piece of land, use
So
of
now,
that land.
In this case, there is no particular regulation in play, is that correct?
In this Roma case, you mean?
Municipal- Right, except for the one about accessory use.
Correct, there's no specific bylaw that says you can or can't do it, but it's, the bylaw in general does not allow it. So it is prohibited in this case, that's.
Okay, so, well, is that an argument, or is that a fact that it doesn't?
That's a fact.
I
We agree on that
Okay.
up until Hanlon and the land court decision in this case, which applied Hanlon, you could not land your private, non-commercial helicopter or airplane in Rockport.
Okay.
The bylaw
You
prohibited.
could not because the zoning board said it's not permitted.
Because the bylaw said, the bylaw does not permit it,
Well,
correct?
the
And-
bylaw didn't say you may not have your own heliport. The bylaw said this is used only for residential or commercial use and for no other purpose.
The bylaw is what's called a prohibitive bylaw, which is that if the use is not specifically mentioned in the bylaw, it's prohibited. And that is what we have with non-commercial private.
So if you lose, I assume there are not many zoning laws which speak of private heliports.
So the briefs got into a little bit of dispute about this. I do have a footnote, I think it's footnote 11, where there were a few bylaws I mentioned that do allow it. That certainly wasn't a canvassing of the entire state. Roma says that they don't allow it in residential zones. A couple of them do. So, but I think your point is that many will prohibit it, yes.
So if you're right, I mean, if you're wrong, okay, let's assume you lose, which happens sometimes.
Yes.
Then if somebody wants to put a heliport in a residential area or in a commercial area or in downtown Boston, then they can do it unless the city says you can't and the state says we approve.
That is correct, and we know it's on record, the division will not approve prohibitions, like, as in Rockport.
So, I mean, is there any reason to think that the legislature was even contemplating zoning issues when they were enacting this legislation?
I say, no, they weren't. Roma argues that 39B is a land use regulatory scheme. It is not a land use regulatory scheme. It is a requirement, the first, third, and fourth paragraphs are a requirement that a certain activity be licensed by the state, with an exception for a subset of that activity.
And let's step back. Let's put aside small airports, okay? Well, no, I mean, I assume if they're going to put an airport, say in Newburyport, which there is one near Plum Island, I'm not sure is that an airport or is that a landing area?
So you would look to the, look to the per the statute, I assume you mean, not what it's called. The definitions of an airport is use of land for landing of aircraft other than a restricted landing area. And then a restricted landing area is any use of land or water made available for the landing and takeoff of aircraft. So I'm not sure
Which can include a pond where you do a
Right.
hydroplane.
I'm not
I
sure
gather.
there's a huge
Okay,
difference.
but I mean, realistically, I gather that when these airports, restricted landing areas are being built, they're being built with the blessing of the city or town.
Well, certainly Mr. Roma's was not.
No, I'm referring not to the non-commercial. I'm
Okay.
referring to the commercial landing areas. I assume that we don't have any commercial landing areas where the city or town says, we don't want it here, and it was imposed upon them.
Well, again, I think it depends on how broadly this court will interpret paragraph 5. Because
I'm interpreting paragraph 4. I mean, I'm basically
that's
saying,
exception, right.
I mean, it's to build an airport in a town where the town says we don't want it, or to put even a landing strip, a commercial landing strip, where people are paying for the privilege. I would think that you would not have a city or town saying we don't want it. So it's generally built with the acquiescence or approval of the town.
Yes, unless if it's a state or federal, they are typically exempt.
Okay,
So-
but we have few of those. So when they're passing this legislation, isn't this paragraph 5 really focused on issues like time, like we don't want airplanes flying in after midnight and stuff like that? Is that the kind of
Well,
rules we're speaking about?
That would be preempted by federal law. And that was specifically the Lockheed case, that you cannot put curfews, and you cannot limit the time of flight. So Rockport couldn't say you can't land between 11 and 7.
So what kind of rules and regulations would the legislature have been thinking about when it said you can't do it without the approval of the department?
Well, if it was use and operation as opposed to regulation of the use of land, then extremely limited. And as I stand here, I can't think of something having to do with the operation of flight that a city or town would be able to regulate, but the division would have say over that. But if the legislature was thinking of if this applies to regulation of the use of land, i.e. can they do it at all, then it is not a conferral of authority, as Roma says. It's a restriction on the pre-existing municipal authority, but it does not restrict the towns with respect to non-commercial private aircraft because of the 4th paragraph exemption.
Maybe I'm missing something. In your view, what's the overall purpose of paragraph 5?
The overall purpose is either to confer limited authority on cities and towns to regulate the use and operation of aircraft, which is the term used in the paragraph, on restricted landing areas that are already located in the town, but subject to division approval. Or if Hanlon is correct, and that's not how Hanlon interpreted it. Hanlon interpreted it as a regulation that applies to the regulation of the use of land, which is different per the line of federal cases in the last section of our brief. If that's it, then the purpose is to, again, subject local regulation to division approval, but not for non-commercial private use, for private commercial.
But I thought that paragraph 5 was designed to give the city or town more power than it otherwise did.
Well, that's Roma's argument, and I think that argument would be correct only if it was with respect to regulation of the use and operation. It is incorrect if it applies, as Hanlon said, to regulation of the use of land for this activity.
And that's where perhaps Justice, well, no, I will speak for myself, but then I don't get exactly what kinds of regulations are not federally preempted, which they say we now want states and towns to be able to do.
Separate from regulation of the use of land, so you're talking about operation of aircraft flying. And actually, Chief Justice Gantz, I agree with you. I'm not sure that when you talk about operation of aircraft, that there is much or anything that isn't regulated by the Federal Aviation Act. But in terms of operation of aircraft, there are other issues. Roma points to the statutes that allow municipal regulation of approaches to airports, so long as they are.
Once you're in the air, the feds take complete control over airports. You have no say over when they land, noise. All this is about is land, but it's expansion of airports, it's expansion of space, and you're not. The last paragraph is easy because the Aeronautics Commission is going to control through the last paragraph. But you're saying there's some kind of residual authority for towns, and I'm not saying you're wrong. I'm just trying to understand it because airports expand. They need to make changes. They've got to clear out brush. They've got all kinds of land-related activities. Historically, we look to the Logan, Massport runs, Hanscom Field and Logan Airport. The towns and cities have these municipal airports all over the place. And I'm trying to understand, because they're going to argue that all that's controlled by the Aeronautics Commission, and you're saying the municipalities have a role, and you may be right if it's limited to just this little thing, these little helipads, because they're going to reject almost every single one of them, and we know that.
Many, but not all.
Oh,
Many towns, but not all towns.
towns don't like airports, and they don't like noise and landing, so I'm just trying to get a sense of what you're saying they can do.
Pursuant to the fourth paragraph.
I know what, the fifth paragraph, they're not going to let the towns do very much.
Yep.
But what are you saying they can do without the fifth paragraph to airports and landing, not just these little private ones, but how much power do they have? Separate and apart from the fifth paragraph.
So separate and apart from, so not including the non-commercial private ones.
Right.
So you're saying separate from those.
You're arguing that they can do whatever they want in the non-commercial private because they're the sole regulatory body, right? Am I correct?
Pursuant to the fourth paragraph.
Right.
Yes.
And
And
although the fourth paragraph only says the Aeronautics Commission has no power, it doesn't say you have any power.
No, but the
you're
Hormel
arguing
Amendment and Zoning Enabling Act before that says that
Right,
they
and
do.
that's what I want to understand is how much power you're saying they have, because that could be a big deal.
Okay. So over non-commercial private, they can ban them.
They
That's
can
what
do it.
I'm saying.
You're saying they are the primary regulator of these things.
Who is?
The cities and towns.
Okay.
The primary, they can ban them.
Right. That's your argument, right? I
Yes.
just want to make sure I understand. Your argument is Aeronautics Commission has nothing to do with these private things. The cities and towns are the primary regulator, right?
So far as the use of land for them go, yes.
I just want to make sure I understand. The second part you're saying, and they also have some other power because they've got residual power that's separate and apart from the fourth paragraph and the fifth paragraph, right?
If the fifth paragraph is, as Hanlon found, a land use regulatory, then they don't. Or they don't, at least so far, it needs to be subjected to division approval. They don't have the residuary
I
power.
get the fifth paragraph. I'm not worried about the fifth paragraph because they're going to weigh in.
Right.
What I understand is you've got an argument that we didn't hear before in Hanlon that says the municipalities have residual power over land and airports.
Yes.
And I just want to make sure I understand how powerful it is. Does it go beyond these little private landing strips, or is it something bigger?
It would, because.
Oh, that makes me nervous then.
But the fifth paragraph would limit it.
No, because you're saying the fifth paragraph is a separate issue, but they have residual power as under their zoning rights, right?
But which is then explicitly and specifically limited by the fifth paragraph for private commercial.
So and again, I don't mean to put words in your mouth because I just want to understand it because it's such a messy statute. Are you saying then that, right, if we overturn Hanlon, all we're doing is saying you can regulate non-commercial private landing areas and you have no extra power unless the division approves the bylaws.
Over the regulation of the use
So
of
there's
land
no
for these
other
things.
residual town and city power.
Correct, because of the fifth paragraph. There is, when you use the word residual, I guess I would use the word pre-existing.
And I don't mean to dominate, and I apologize, but just, but the paragraph 4 doesn't give you any power in itself. It
No.
just wipes out their power.
Yes, absolutely. The fourth paragraph is not what gives the cities and towns the power. It is the Home Rule Amendment, and prior to that, the Zoning Enabling Act.
Okay, I'll be quiet.
Okay, well,
Can I ask
Yeah,
a
go ahead.
question? Which is, excuse me for being sort of simple about this, but when the division takes it into account, somebody asks to use land to have, private land, like Mr. Roma, for a helicopter pad, and the division approves it, which is what happened here, right?
The division does not have any approval authority. All they need to do is be notified of that
They
type
were
of use.
notified of it.
They were notified.
So they don't do anything by way of weighing whether or not it's an okay thing to do or not, what kind of impact it's going to have on the neighbors or what kind of impact it's going to have on the town. They don't do
Absolutely
any of those.
correct.
None of those calculus factors enter in.
Absolutely. If you look at the notification form, which is in the appendix, you can see what information the owner has to give, and it has nothing to do with any of those interests and issues that you just raised.
So if the municipality can't regulate that, nobody does.
Nobody does, exactly, because the division certainly does not.
Okay, so that's the question.
okay.
Is it unregulated completely? Okay.
Yes.
And
Thank you.
Going back, not so fast, going back to Justice Kafker's point, let me make sure I understand it. If you win here, pragmatically, that means the town of Rockport can say, we don't want private heliports in some or all parts of our town.
That is correct.
But are you also saying that the town of Rockport, if there were to be a commercial landing area in Rockport, could impose zoning limitations on the commercial landing area?
No, that would need division approval.
Okay, so you're speaking only about individuals or companies seeking to put essentially a private landing strip on their land or a heliport on their land,
Yes,
not a commercial landing area or an airport.
yes,
That would be the province of the division. You could do it, but only with their blessing.
yes.
Okay.
And in our brief, we explain why it makes sense to make that distinction between commercial and non-commercial.
We just go back for one second, and is the prohibition, the prohibitive regulation that, because this is not a listed accessory use, would that have to be approved by the division?
If Hanlon holds, if I lose, then yes. And we already know it would not be.
Thank you.
Okay, thank you.
Thank you.
Mr. Shapiro, good morning.
Good morning. If it pleases the court, I'm Nicholas Shapiro, Phillips and Angley for the plaintiff appellee Roma 3 Ltd. Before I get into the main thrust of my argument, I did want to clear up one issue in terms of the regulatory sphere. The regulations, the land use regulations that a city or town can adopt pursuant to the fifth paragraph of 39B would constitute tertiary regulation in this area. Pursuant to federal law, any party who wished to have a landing area would need to seek a airspace suitability determination from the FAA. And in this particular case, it's unfortunately it's not in the record because I didn't believe it was relevant to the preemption issue in this case. But in the background in this case, our client owns another house down the same road, and he went and tried to get an FAA airspace suitability determination for a helipad at that house and was turned down.
And why?
Pardon?
Why?
Why did he? For the same reason that he was seeking one for his other house.
Why was he turned down?
He was turned down because it would be unsafe, because it was too close to houses.
Okay, so it wasn't because they didn't have any regulatory authority.
It is absolutely true that the FAA, well, it's a little bit of a metaphysical question. The FAA, as Justice Kafker said, under federal law, the airspace is completely regulated. Once an aircraft leaves the ground, it's completely within federal jurisdiction. There's an express preemption provision of the Airline Deregulation Act from the 70s that preempts all regulation as to service, routes, and rates. And so, but frankly, the notion that all zoning is left to local concern, I think, is not true. Burbank, in fact, I believe, dealt with a zoning ordinance that purported to impose a curfew on an airport.
But
So,
this isn't really about all zoning, isn't it about just some zoning?
correct. According to even the town's position here, it's the aeronautic statutes are comprised of 60 discrete statutes enacted between 39 and 55 in an area that the federal government has already regulated quite a bit starting in 1926. So the question is, what was left for the state to regulate? And so that's why 39B, to get to one of the conversations that was just had, 39B is a land use regulatory statute.
But before you get into the weeds.
Sure, yes, absolutely.
Because I have a question that stems from this. Could you continue and tell me the three areas of regulation that?
Sure, absolutely.
So you said the FAA airspace.
Right, airspace, and then you want, for a NCPRLA, you would have to go to the division and register.
These
Non-commercial
initials mean
private
nothing.
restricted landing area. It gets even more confusing because the regs define private restricted landing area, which is an NCPRLA, and includes a safe harbor even for businesses that have NCPRLAs, as long as they're incidental to the business rather than the business itself.
And what does the division look for? Is it still a suitability, airspace suitability?
So it's, I have to unfortunately disagree vehemently with opposing counsel on this point that it is not no regulation. You have to register. The division inspects the premises as part of that, as part of that registration process. And the statute in the 4th paragraph, in exempting NCPRLAs from the certificate of approval regime, which is more of a full permitting regime, requires that the NCPRLAs be maintained in a way that's safe. So the inspection is purposefully to determine that this NCPRLA is not going to pose a hazard to the public safety. And frankly, the FAA and the division are in a better position on those primary and secondary lines of regulation to determine whether, from an aeronautics perspective, this really poses a public safety threat.
That goes, safety is not the same thing as living in a neighborhood that has a helicopter landing, next door to you.
Absolutely, Your Honor. But this is why
Noise and all the other, and dirt and all the stuff that
absolutely,
comes-
and that's why the tertiary authority to regulate these landing areas is bestowed on cities and towns, subject to division pre-approval. The division looks very unkindly on tacit, thoughtless, implied bans of all landing areas because there's a dual mandate in the aeronautics statutes to promote public safety, but also to promote aviation, which includes air commerce and private flying. The town's position in this case would toll the death knell of non-commercial private restricted landing areas throughout the state. Cities and towns could just, without thought, through their prohibitive bylaws, which are prohibitive regardless of whether there's an express provision under Maxent, can just stamp these things out of existence.
But on the other hand, if we adopt your position, is it not true that anybody could put a landing strip anywhere and a town wouldn't be able to do anything?
That's absolutely not true, because what happened to my own client when he sought an airspace suitability determination from the FAA for another property because it was unsafe in relation to.
Unsafe is not the same set of considerations that the municipality is going to be taking into account.
But again, municipalities are free to reasonably regulate
Well,
these
what is
things.
a reasonable regulation that a division approval has been obtained for?
I beg your pardon, Your Honor?
When does a division approve something that a town says is?
Based on the dual mandate. So the dual mandate is, are you thwarting the promotion of aeronautics in the Commonwealth, or are you properly considering safety considerations?
Isn't there an inherent conflict? Because to pick up on Justice Link's point, as far as the considerations of the neighbors and the like, that's within the province of the city and town. The division and the FAA are more geared towards airspace and promoting aeronautics. The city and town is responsible for the safety and welfare of the neighbors, correct? So you're telling me that if the division comes in and says, well, the helipad's fine, there's plenty of room, and then the town says, we don't want you here because you're in a crowded neighborhood, the interests of the division in promoting aeronautics are going to trump the concerns of the neighborhood.
Well, so I'm not unsympathetic to people who have to live around landing areas. I understand fully that that's probably not something that anybody would relish. But the general court, when it adopted the aeronautics statutes, all 60 of them in an area that was already, a regulatory sphere that was already crowded, the general court specifically called out the promotion of aviation, the fostering of air commerce, and private flying as something that this Commonwealth values.
Well,
And
but private flying, you're saying private flying means a private landing strip?
I think in terms of the democratization of trying to actually encourage more people to be able to engage in aviation.
Democratization?
I know it's the way it
I mean,
stands
anybody,
right now,
no matter
if
how
you
poor, can
don't
have a
an-
landing strip on their expansive property to fly their helicopter?
Admittedly, my client has hangar space at Beverly Airport, but this statute is for all the citizens of the Commonwealth. And if you stamp out NCPRLAs throughout the country, I mean throughout the Commonwealth, including out in Western Mass in less densely populated areas, you're essentially saying to people that you cannot engage in aviation unless you have hangar space, and that ups the transaction cost for anybody who has any interest in it.
Or unless you have hangar space, or you have approval from the town in terms of this private landing strip.
By and large,
What's wrong with that?
because bylaws and ordinances are either expressly prohibitive or impliedly prohibitive under Maxent, most bylaws and ordinances are going to ban these types of airstrips without thinking about it, right? So you'd have to go out and get a use variance in order to be able to have that landing area. And a lot of bylaws don't even allow use variances as they're allowed to under the Zoning Act.
There are a lot of activities that municipalities have not regulated because it has not occurred to them that they have to. Driving your elephant through the drive-through, which has been done. So,
But not by you.
But not by me, no. So. But in your town. But in my town. So at some point, the municipality does have an interest here. Don't you agree with that?
It does have an interest, but that's why it's been given conditional authority over this sphere. It certainly has an interest. The difference between the elephant going through the drive-through and private landing areas is that there isn't a legislative mandate to
10 statutes on elephants.
Right.
But
So
that's the legislative mandate. You say that the purpose of Section 5 was to expand, was to permit towns to regulate where they otherwise could not.
Correct, Your Honor. And
But
that's
so the legislature says, okay, Section 5 has been added so as to give cities and towns more authority than they used to have.
Correct.
And you're saying, oh, no, actually, Section 5 has the consequence of eliminating the zoning authority of every city and town over a private landing authority.
No, Your Honor, I don't believe that. I believe that the 60 statutes that the General Court enacted between 1939 and 1955, years before the Home Rule Amendment, had the effect of filling the field so that as of 1985, when the amendment was adopted, there was no residual authority in cities and towns to regulate landing areas. 39B sets up a comprehensive land use regulatory scheme for landing areas.
And now you're saying Section 5 doesn't matter.
No, Section 5 certainly matters to the extent that there is now tertiary regulatory authority in cities and towns to regulate these areas. But they just have to think about it, right? Because up to this point, they're not even, they want to be able to tacitly ban these
Have to be an
things.
express prohibition. Is that it? Or
yes.
express limitation? Is that what you're saying?
Well, in the record, there's an affidavit from the administrator of the division, and in which he avers that, generally speaking, the division does not look favorably upon tacit bans of aeronautics. So it does have the practical effect, paragraph 5 has the practical effect of making cities and towns think about these things, not just thoughtlessly ban them.
Well, okay, as I say, give me one that's okay.
One that would be well, unfortunately, that's not the case before this
You haven't
court.
got one? It's not,
Well, so it would have to modulate the needs between public safety and the promotion of aviation, and would
Public
allow cities
safety.
and towns to.
public safety. We're talking about living in an area and not wanting a helicopter to be right hovering ahead, you know?
Again, Your Honor, I'm not unsympathetic to if you were living next to a heliport, you would, but the
don't-
difference is that the legislature has spoken that this is something that we want to
Question is,
value.
has the legislature spoken about this? I don't-
Absolutely, in terms of the mandate that the division is.
Flight is primary. We promote flight over other interests. That's what we do.
That's the point of having the fifth paragraph, which allows cities and towns,
But
as
you
long
can't
as they
think of
properly
one-
honor the dual legislative mandate, they're free to consider normal zoning considerations, which means you could have setbacks. You could have lot minimums applicable to having certain types of landing areas. All of these things would be perfectly acceptable, and they would also have the laudable goal under the aeronautic statutes of not prohibiting, not stifling the promotion of
But
aviation.
does your sister does she provide a way out of this mess, which may make sense in the statute, which is all they can regulate, all the towns can regulate is just this one little thing, which is your major concern are the airports, right? The commercial airports, the town airports. You're not that caught up in what the individual landing strips, these little helipad, meaning the aeronautics.
As the attorney for somebody who has.
I understand,
right.
but it seems like this proposal may make some sense. I mean, the biggest problem is the commission's going to reject every one of these, and the towns and cities are going to reject every single one of these creations. They're not going to allow these. But it does seem to make some sense, and the legislature may have made this decision, that the cities can regulate only this little thing, which is their core concern.
As an abstract proposition, that makes some sense. The problem is it's completely acontextual when you look at the statutes.
No, it isn't, because the statute seems to be recognizing diminished authority of the commission over these non-commercial private regulatory ones. But at the same time, it makes some sense for zoning to have some residual effect.
Well, it does under paragraph 4. But let me explain to you, Your Honor, why it's acontextual. Mm-hmm. The exemption paragraph 4, is intended to impose less regulation on these low-impact landing areas.
It's intended to impose less regulation by the commission on these things, but not necessarily the town. But what worries me about your sister's argument is she's suggesting the town has some residual authority in aviation, which seems inconsistent with the whole statutory framework outside of this little bit.
Having just canvassed this court's case law on state law preemption, I would like to turn your Honor's attention to Doe v. the City of Lynn. One of the major reasoning points of this court in determining that the City of Lynn could not adopt a zoning ordinance regulating where registered sex offenders could live within the city was because within the scheme, within a broad regulatory scheme, broad detailed regulatory scheme, when the legislature decides to impose lesser regulation on a particular activity, that has meaning. Silence or lesser regulation within the context of a comprehensive legislative scheme means that is to the exclusion of subordinate political entities from imposing more onerous regulation. In particular, this court looked to the fact that there was some regulation in terms of where Class 3 sex offenders were allowed to live. They're not allowed to live in group homes. And so this court said, this has meaning. The fact that the legislature imposed lesser regulation doesn't mean that a city and town can go and pass more in the context of a very comprehensive, very deep statutory scheme. Likewise, in Arizona v. the United States, the fact that undocumented immigrants obtaining employment is not per se a crime was to the exclusion of Arizona being able to make it a crime to be an undocumented immigrant working. So in the context of a very comprehensive statutory scheme, the imposition of less regulation itself is an indication of preemption. And that's probably the town's main argument, but if anything, it's actually evidence of preemption rather than the opposite.
But I'm afraid you've confused me. Is it your position that Section 39B doesn't matter in terms of the authority of a town to impose zoning restrictions? That there's some other preemptive guidance that says a town can't impose zoning restrictions on a non-commercial private landing area?
Well, there's a number of direct conflicts. One would be that the fourth paragraph is intended to impose less regulation on non-commercial private restricted landing areas, not to confer on cities and towns the ability to outright ban them. And the notion that in 1946, the general court was thinking about home rule authority over landing areas is just factually impossible. Another direct conflict is the language of the fifth paragraph itself. If it reads as the conference of authority, that necessarily means there wasn't authority before. And so this was the legislature indicating its understanding that this pre-home rule amendment statutory scheme that's quite broad filled the field in terms of local regulation of aviation over everything that was left after federal preemption, including land use, because 39B itself was adopted initially as a land use regulatory scheme for landing areas.
So your view is that if Section 5 had never been passed, nothing changes here?
No, Your Honor, because the final direct conflict is that the objective, the policy objective of the aeronautics statute is to promote aviation. And that is specifically spelled out as fostering air commerce and private flying. And you cannot foster private flying by allowing cities and towns without thought to stamp non-commercial private restricted landing areas out of existence. Those things cannot be reconciled. And finally,
Why can't you reconcile it with having small municipal airports where, you can have a hangar?
because that again raises transaction costs, Your Honor.
Well, so what?
But beyond that too, what would be the point of the legislature creating a concept such as a non-commercial private restricting landing area to then just allow cities and towns to make it not exist? It would be essentially factually nullifying,
They could, I guess, in
practically
areas where
nullifying.
you don't have the same kinds of concerns, right?
I
could
beg
have,
your pardon, I'm
like,
sorry, Your Honor.
People have 40-acre farms. I mean, it's fine.
Well, but that's the whole point of the fifth paragraph's pre-approval requirement.
But the
If
Pre-approval requirement, what does it really mean?
the pre-approval requirement would be, yes, if a city or town,
Approval.
the approval would be from the division. So the division would look at this proposed bylaw, which specifically, affirmatively is seeking to regulate landing areas, and would say, well, if it's setbacks and if it's lot minimums, maybe even if it's a ban in certain districts.
Could it be a density?
Of course, yeah, absolutely. Maybe it's even a ban in certain districts, as long as it's not.
Your parade of horrors doesn't take into account that zoning can't be arbitrary and capricious, that they still are subject to, and if they just say, we have a blanket prohibition against the private landing area, even if it's in the middle of a 40-acre farm, that may be arbitrary and capricious, and the zoning wouldn't fly.
Right, we do have a substantive due process rational basis claim in this case, but as your honors know, that's a very high bar. And in some sense, the decisions like Maxent and Garabedian prove the need for preemption, because if you don't have the aeronautics statute protecting this type of accessory low-impact landing area, you're never going to get to a critical mass of use so that it could be customarily incidental in the first place. And so again, I'm not at all unsympathetic to your honor's concern as a private citizen having to live next to it. But
how customary and incidental could private helicopter landing areas be? We're not chock full of them, are we?
right, right. But the point of the statute is to allow the promotion of aviation so that we get to a place where that actually would meet the legal
But we want to
standard.
have private helicopter pads all over the place?
Again, Your Honor, because there's 3 levels of regulation, that parade of horribles is just
That's
not.
what it takes to promote aviation, is to have private helicopter pads wherever you want them?
That is not what the law provides, Your Honor. If you have to get an airspace suitability determination.
No, it's safe. So that you can satisfy the concerns of the FAA. I guess the division doesn't really have to be satisfied because it's just going to get notified, right? And there's no certification of approval.
Well, the statute, the fourth paragraph, if Your Honor looks again, the fourth paragraph requires that it be maintained in a way that's safe.
Okay,
So
safe.
it gets
we're talking about
inspected so that it's
safe.
safe.
How often does it get inspected?
I could speak to, our client got inspected right when he was seeking to be
Ever
registered.
again?
The regs contemplate every 5 years.
So, but safety is not the only consideration that's at play here. Safety and the promotion of flight are not the only concerns.
Well, and that would be the reason why the fifth paragraph exists, so that so that the division can allow the modulation of conflicting policy objectives.
But the division isn't
Safety.
necessarily going to take into account the concerns that the zoning board would be taking into account in modulating those concerns.
I would submit to Your Honor that the fifth paragraph would allow cities and towns to consider their usual zoning interests as long as they still fit within the dual mandate of the aeronautics statute, which is the promotion of aviation and the protection of public safety. That's the very purpose of the fifth paragraph.
But the fifth paragraph is broader than the fourth paragraph, because the fifth paragraph refers to airports and all landing areas,
Correct.
not just. So I understand why the fifth paragraph has to go before the commission, because that means the towns are getting involved in airports. And they're not just getting involved in these little heliport type things. That seems
right.
different. I mean, it seems like the legislature is conscious of different levels of regulation based on what we're dealing with, whether we're dealing with an airport, a landing area, or a NC, a private one. Now it starts to make a little more sense to me that they would say the towns could just do this little bit.
But that honestly, Your Honor, there's no record evidence as to that being what the general court was thinking about.
Yeah, but we have to make sense of what they're doing here. And it's also 46 they're doing this?
So in 46, they passed the exemption. And the manifest purpose of the exemption was to impose lesser regulation on non-commercial private restricted landing areas. The notion that
Lesser regulation by the Aeronautics Commission. They don't reference towns or cities in that fourth paragraph, right?
correct, because preemption was a reality at that time.
Preemption
But
of
that's
everything?
I'm trying to
I
understand.
mean, I'm sorry, preemption wasn't a reality at that time, but there was no home rule amendment, and whatever power was conferred under the Zoning Enabling Act, there would be a repugnancy between the power conferred by the Zoning Enabling Act and the aeronautics statutes. I mean, we wouldn't have a whole bunch of airports in this Commonwealth if cities and towns were allowed willy-nilly to regulate landing areas as a matter of the Zoning Enabling Act pre the Home Rule Amendment.
Your sister's not arguing that she's got any power over anything but these non-commercial private landing areas. At least I think that's what she's arguing.
That is what she's arguing, but there's no evidence that the general court was thinking about passing along authority
But I can see
to
why.
cities and towns through the fourth. You'd have to change the meaning and intent of the fourth paragraph through the fifth paragraph, and there's all sorts of case law to the effect that we don't view legislative intent based on what future legislators think. We don't try to we won't transubstantiate what the intent was
But the
in the
fifth paragraph
past.
is much broader. It just deals with everything. It deals with airports and commercial landing areas. It's not just the fourth paragraph.
Hence the appeals court's decision in Hanlon that the fifth paragraph doesn't speak of limitations. The fifth paragraph grant of authority on its face would appear to apply to all landing areas. And so this is why this is not a straightforward plain meaning case, because the town wants to elevate the plain meaning, according to it, of the fourth paragraph adopted 40 years earlier over the plain meaning of the fifth paragraph. The plain meaning of the fifth paragraph reads as the grant of authority to cities and towns to regulate all manner of landing areas, subject only to division pre-approval. It doesn't speak in any type of limited sense. It's only the fourth paragraph that does, and so hence the incongruity as the panel described it in the Hanlon decision. And under those circumstances, this court is charged with, well, what was the legislature intending to do? Well, in '85, the legislature was intending to grant authority where there hadn't been any authority to cities and towns to regulate all landing areas, subject to one simple condition, which is that the division pre-approve those regulations so that they, in exercising their zoning power, actually also comply with the dual mandate of the aeronautics.
I guess there's a certain, one of the things I'm having trouble dealing with is you say the legislature intended to strip all cities and towns of any authority, any zoning authority over these private non-commercial landing. That's what the legislature did. And you also say that no city or town would ever permit it. So, but these legislators come from those cities and towns. So show me where, if I'm a legislator and you say this is what you did, I would understand that I, a legislator from the very cities and towns which would never permit this pursuant to their zoning laws, have said, I'm going to strip the cities and towns of that zoning authority.
To be clear, Your Honor, I don't read the fifth paragraph as a affirmative express preemption provision. It doesn't say no city and town shall adopt, promulgate ordinances, bylaws, and regulations that govern the siting of landing areas. It reads as the grant of authority.
Right, I understand.
So in reading as the grant of authority, that necessarily implies that there hadn't been authority
But show
previously.
me where it is written. Show me where there is a law that says that. I mean, if I'm a legislator and I say, "Golly, I don't remember ever doing that," show me the statute which says this is where you did it.
As this court held in Bloom, a conceptual difficulty is imposed when this court has to pass on whether a pre-home rule statute preempts local law, because quite obviously the general court wasn't thinking about preemption before the home rule amendment.
There was zoning before there was home rule.
Correct, Your Honor.
There would have been zoning in 46.
Right, and the Bloom court also said that the repugnancy standard is essentially the same as the preemption standard, right? So this is by definition, because we're talking about a statutory scheme that's pre-home rule amendment, it is necessarily an implied preemption case up until 1985. And so the question is this statutory scheme so comprehensive? Does it address so many things in such great detail? Does it control how cities and towns operate within this sphere? Do city and town enactments, do they run contrary to the legislative purpose of the aeronautics statute? And here, literally, every single box has been checked in terms of the preemption factors that this court has articulated. And beyond that, you also have that this has been the consistent interpretation in the Commonwealth from an AG's letter in 1939 to the letter of the MAC proposing that the fifth paragraph of 39B be adopted, all the way to the amicus brief in Hanlon to the amicus brief in this case.
That was the position of the division. That was not the position that the land court thought reasonable, though.
That is correct, Your Honor. But in Chevron deference, it's not a court's view of the matter that would be accorded deference. If the statute doesn't,
to the division's view, you're saying we have to accord deference to the division's view of the statute.
Assuming the Chevron
But that is
prerequisites
not,
are met, which is,
generally
does the
applied in
statute speak to this issue expressly? And I think Chief Justice Gantz has already said that it doesn't speak directly to this question. And so if it doesn't speak directly to this question, then and it's a supportable interpretation of the overall statutory scheme, which I think it can't arguably be not, then it is to be accorded deference. Because again, remember,
adopted Chevron deference in Massachusetts?
we have.
We have?
Yep. The Goldberg case cited to in our brief specifically applies Chevron. And Bloom specifically refers to federal law as being highly persuasive governing the preemption inquiry. In our brief, the FCC v. City of Arlington decision from the Supreme Court specifically says, in determining whether Chevron deference should be applied to jurisdictional questions, it applies to questions of preemption. Chevron deference even applies to statutes that constrain agency authority, which paragraph 4 would seem to constrain agency authority. So under these circumstances, if the division believes that the meaning and effect of these incongruent provisions is that the fifth paragraph applies to all landing areas, and that issue is not specifically addressed by the statutes, it is to be accorded deference as long as that interpretation is reasonable. And I would submit, because all of the indicia of preemption are present here, comprehensive scheme, direct conflict with legislative mandate, pervasive control over local actors. I mean, the statute even requires municipal officials to cooperate with the division. Based on all of this, it just is simply not possible for this court to conclude that the division's interpretation of the statutes is unreasonable based on the existing case law.
I have one other question related to something you said earlier, and that was that an FAA approval was sought for another piece of property?
No, for a different property down the road, and that was denied, and that's the end of the story. You don't even go
So
beyond
my
that.
question is, was that sought for this property?
It was, and it was
and
obtained.
granted.
Right.
Okay.
Okay, you can tell Mr. Roma that you work double time.
Thank you, Your Honor.